Hello! The revised draft regulation for qualified patients and caregivers has been released. The Missouri Department of Health and Senior Services released a number of revised draft regulations for medical marijuana.
My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law.
Now, I'm not going to completely review the entire draft rule, as I've already done so in a previous video. Today, we're going to focus on the changes and important parts of the rule. This video will focus on the revised draft rule for qualified patients and caregivers, 19 CSR 30-95.030. The department says that in the rule that the department will receive applications for qualifying patients, primary caregivers, and patient cultivation electronically through a department-provided web-based application system. In the event of application system failure, the department will arrange to accept applications in an alternative department-provided format and will notify the public of those arrangements through its website. Clearly, someone has paid attention to what I've said about the likelihood of the state system crashing under the weight of applications. This isn't a criticism of DHSS. It's merely an acknowledgement that they are attempting to build a new web processing system from scratch, without really knowing the user levels and not being able to truly stress test it before releasing it in the wild. I expect this system to crash a time or two. And if you are seeking a patient card, don't stress out on not getting your application in on the first day. There isn't likely going to be any medical available until early to midsummer 2020 anyway. The department has thus far retained the illegal and unconstitutional Section 2A3, which requires a statement that you do not intend to ever move out of the state of Missouri. Quote, a statement that the qualifying patient primarily resides in Missouri with the intention of permanently or indefinitely residing in Missouri, as well as proof of current Missouri residency. I expect someone is going to honestly say they intend to move elsewhere in a fixed period of time. I don't know, like after college, and be denied. That person will sue and win. I filed my suggestion to amend that by removing the intention clause. I would suggest that you file your suggestion as well. Section 2A10 clarifies the requirements for home cultivation. If the patient is seeking authority to cultivate medical marijuana, they have to provide the address of the facility in which the qualifying patient will cultivate marijuana, B, a description of the security arrangements and processes that will be used to restrict access to only qualifying patients and their primary caregivers. C, the name and patient license number or caregiver license number, if applicable. If one of the other qualifying patient or primary caregiver with whom the cultivation facility will be shared. F, a statement affirming the applicant's agreement to immediately make available access to the patient cultivation facility upon request from the department. Now, I still have my reservations on the use of the word immediately in regards to making access to patient cultivation facility on request from the department. This presents an issue, especially for the home grower. If you are growing at home and happen to be on vacation in Denver, are you in violation? Yeah, you could be. This seems to be setting up a move to drive individual cultivation to a contracted cultivation facility, which really seems to defeat the purpose. When this rule is finalized, I will publish an information guide for the home cultivator with advice on how to comply with these rules. Section 4 of the regulation is extremely important. A cultivator may grow up to 6 flowering plants and up to 6 non-flowering plants in an enclosed, locked facility as defined in 19 CSR 30-95.010, which is, quote, A, an indoor stationary closet, room, or other comparable space equipped with locks or other functioning security devices that permit access to only the qualifying patients or primary caregivers who have informed the department that this is a space where they will cultivate marijuana. Or B, an outdoor stationary structure, one that is enclosed on all sides except the base by chain link fencing, wooden slats, or similar material that is anchored, attached, or affixed to the ground and that cannot be accessed from the top. 2, in which the plants are not visible to the unaided eye from an adjacent property when viewed by an individual at ground level or from a permanent structure at any level. And 3, that is equipped with locks or other security devices that restrict access to only the qualifying patients or primary caregivers, who again have informed the department that this is the space where they will cultivate marijuana. You know, the reg states that nothing in the reg shall authorize cultivation in a place where it is prohibited by law or by private contract. Again, if you are renting property, you need to make sure that your right to grow and consume your medical marijuana is protected. Now, I have a packet of lease addendums on pattalkslaw.com that will help you do so, whether you are the landlord or the tenant. The packet is only $25 and it's well worth the peace of mind and protecting your rights. Now, finally, disposal of excess marijuana is something they've elaborated on. If you should lose your card for some reason, Section 9 states, disposal of qualifying patient medical marijuana. A, in any case where a qualifying patient is no longer entitled to medical marijuana under any provision of state law, or is deceased, any excess medical marijuana or marijuana plants in the possession of the qualifying patient or the patient's primary caregiver, or discovered by a third party, shall be turned over to a licensed dispensary for disposal within 30 days of the event that makes the qualifying patient ineligible. 1. Before delivering the excess medical marijuana to a dispensary, the individual in possession of the excess medical marijuana must contact the department, and then the department will coordinate delivery arrangements between the individual and the dispensary. And 2, the individual in possession of excess medical marijuana shall receive from the department written temporary authorization to transport medical marijuana. And that authorization shall include details regarding delivery arrangements that have been approved by the department. In Section B, the possession and transportation of medical marijuana under this section shall not subject the possessor to arrest, criminal, or civil liability or sanctions under Missouri law, provided that the possessor produces on demand to the appropriate authority a copy of the temporary authorization for transport or evidence of communication with the department regarding delivery arrangements. Now, these revised rules have elaborated on some things. There are still some issues. I would hope that you please go to the Department of Health Senior Services website, go to the draft rules section, and submit a suggestion. The section regarding the intent to remain in Missouri forever or indefinitely, that's got to be changed. You absolutely have a right to plan to move in 10 years to Alaska if you choose to do so. That does not mean that you should be denied your equal access to rights in the state of Missouri because of an intent to leave the state at some point in the future. That has to be fixed, and if enough of you file your suggestions, it will be. So thank you very much for watching. We will have more on these revised draft rules coming out over the next couple days. They're going to come rapid fire, I'm planning on shooting several of these today and releasing them over the next couple of days so we don't overwhelm YouTube's logarithms. So please subscribe, hit the like button so we know you liked it, and hit the alarm bell, the alert bell, so that you'll be updated when we get the next video published. Thank you.